This week, we are pleased to bring you one of our most popular episodes of 2024. Please enjoy, and we'll be back next week with more insights from the Corruption, Crime, and Compliance podcast.
It gets on the issue of third-party liability. When are you liable for your third-party diverting, let's say, products to a prohibited entity or prohibited country? The classic case is Company A sells its product to distributor B, who resells the product to customer C in Iran. Is Company A liable for that sale to customer C in Iran?
Global companies face unprecedented risks and challenges in today's economy. To mitigate these legal and economic risks, companies are rapidly embracing and elevating the importance of robust ethics and compliance programs to promote positive corporate citizenship. On Corruption, Crime, and Compliance, you'll hear from industry leaders and insiders about how to create effective ethics and compliance programs that will mitigate risks and maximize financial performance. Here's your host, Michael Volkov.
Welcome, everybody. This is Michael Volkov, and you're here for Corruption, Crime, and Compliance, another episode. This one is on the 4 sanctions compliance cases that everyone should know. Welcome, everyone. Hope you're doing well, enjoying the weekend. The Justice Department now has repeated on several occasions that it intends to aggressively prosecute corporations for sanctions and export controls violations. And we've heard the term the new FCPA. We're still waiting, and we're still waiting for the sort of sword to drop, but I anticipate it will occur, and we're going to start to see companies reaching FCPA-type settlements. Remember, the DOJ has assigned 25 new prosecutors. That is the most important fact. You can always tell what DOJ is going to do by tracking the resources. And here we have 25 new prosecutors assigned to the National Security Division and with a specific mission to bring cases against corporations. Now, in reaction to this new threat and set of corporate risks, DOJ has specifically warned companies to take affirmative steps to improve their compliance programs beyond the implementation of just simply sanction screening software and focusing on a few sanctioned countries. To this end, DOJ has noted the importance of, quote, investing significant additional compliance resources in preventing national security and criminal misconduct, close quote. Now, aside from DOJ's extensive guidance for ethics and compliance programs, OFAC, remember, has issued its own guidance governing sanctions compliance programs, entitled A Framework for OFAC Compliance Commitments, issued in May of 2019. The 5 key elements of an effective sanctions compliance program: management commitment, number 2, risk assessment, number 3, internal controls, 4, testing and auditing, and 5, training. But to prepare for this new set of criminal enforcement risks, legal, ethics, and compliance professionals will need to familiarize themselves with several significant cases in this area. And I want to focus on these 4 cases because I think they each have an important lesson learned and an important aspect to follow up in building your sanctions compliance program. So let's talk about the first case, which I would call the British American Tobacco case. In DOJ's criminal settlement announced on April 25th, 2023, with British American Tobacco was for circumventing North Korea trade sanctions, and it provides an important example of what a corporate prosecution is going to look like. And it looks like an FCPA settlement where there was systemic deficiencies and bribery occurring. So British American Tobacco, I'll call it BAT, BAT's subsidiary in Singapore was required to plead guilty to criminal sanctions conspiracy, and BAT's parent company entered into a 3-year deferred prosecution agreement. BAT paid a penalty of $629 million. OFAC also announced a settlement under which BAT agreed to pay a portion of the $629 million that goes to OFAC as well. In another action, DOJ brought criminal charges against a North Korean banker and Chinese facilitators for their roles in the illicit sale of tobacco products in North Korea. BAT's subsidiary in Singapore pled guilty to a 1-count information and charging it with conspiracy to commit bank fraud and to violate sanctions. And BAT entered into a 3-year deferred prosecution agreement. Now, BAT did not voluntarily disclose the conduct, and OFAC characterized BAT's violations as egregious. Also, OFAC cited the fact that BAT tried to hide the transactions and payments through a complex remittance structure that relied on an opaque series of front companies. BAT's upper management had actual knowledge about the conspiracy. Now, we didn't see prosecution of any individuals from BAT, and the reason why, probably because of statute of limitations issues. Because between 2007 and 2017, BAT processed payments for tobacco sold to North Korean entities through a third-party company totaling $418 million. To make the payments to BAT, North Korean purchasers used front companies so that U.S. banks would not know about the connection to North Korea. And U.S. financial institutions processed at least 310 transactions worth approximately $74 million. Now, BAT cooperated with the investigation, and under the OFAC settlement, BAT agreed to maintain sanctions compliance measures for the next 5 years, including by ensuring its management promotes a culture of compliance. BAT must also conduct an OFAC risk assessment, maintain written compliance policies and procedures, conduct internal and external audits, train its staff, and submit an annual compliance certification. So a $629 million settlement, it looks like an FCPA case in the sense that there's a criminal plea, there are related criminal cases, and we also had individual prosecutions of the North Korean or the Chinese facilitators as well. So let's go to case number 2. Case number 2, an important case here, and it gets on the issue of third-party liability. When are you liable for your third party diverting, let's say, products to a prohibited entity or prohibited country? The classic case is Company A sells its product to distributor B, who resells the product to customer C in Iran. Is Company A liable for that sale to customer C in Iran? And this case is Epsilon Electronics, the United States Department of Treasury, a Court of Appeals case in the U.S. Court of Appeals for the District of Columbia. And in reviewing an OFAC enforcement action, the U.S. Court of Appeals affirmed in part 34 transactions and reversed in part 5 transactions. OFAC's and the district court's decision affirming OFAC's enforcement action against Epsilon Electronics, a subsidiary of Power Acoustic. OFAC began investigating Epsilon in 2011. When OFAC learned about a 2008 shipment from Epsilon to an address in Tehran. OFAC issued a warning letter as a result of this investigation. Later in 2011, OFAC learned that Epsilon had received multiple wire transfers from a Dubai bank made on behalf of Azra International. That's going to be the key third party. OFAC examined Azra's website, which referenced the company's success in the Iran market, listed dealers located in Iran, and displayed photos from trade shows in various Iranian cities. Some of these photos appeared on Epsilon's U.S. website. OFAC then initiated an investigation. In May of 2012, OFAC sent Epsilon another administrative subpoena requesting further details on the company's transactions with Azra and with Iran. Epsilon produced invoices for 34 transactions with Azra and 5 additional transactions that occurred during February to May 2012, which were destined for Dubai and not Iran. OFAC imposed a penalty of over $4 million. Epsilon claimed that it did not have any knowledge or reason to know that Azra distributed Epsilon products in Iran. In rejecting Epsilon's challenge to OFAC's enforcement action, the Court of Appeals articulated the standard for liability when an exporter distributes its product through a third party. In other words, when an exporter has quote-unquote reason to know that goods are specifically intended for re-export to a prohibited customer in Iran, then the exporter is liable. Interestingly, the Court of Appeals specifically held that OFAC need not prove that the goods ultimately ended up in Iran, and instead noted that liability attaches once the exporter acts with the prohibited state of mind. Court of Appeals explained that an exporter has taken all the steps that he must take to put goods in transit to Iran, and the goods are then out of his control. No other actions are required to violate OFAC's regulations. The arrival of the goods is a result of his voluntary conduct, not part of the conduct itself, and thus is not a component of the act of exportation. The Court of Appeals further stated that the reason to know standard can be satisfied, quote, through a variety of circumstantial evidence, including course of dealing, general knowledge of the industry or customer preferences, working relationships between the parties, or other criteria far too numerous to enumerate. In affirming OFAC's finding that Epsilon had reason to know that the shipments to ASRA were destined for an Iran customer, the Court of Appeals cited the fact that ASRA distributed exclusively to Iran as late as December 2011. ASRA's website referenced its affiliate in Iran, and it listed only 2 contact locations, one in Dubai and one in Iran, and its website touted its 10 years of experience in Iran. Well, that's the Epsilon case. Really important for when you're dealing with distributors, when you're dealing through a third party and delivering products that ultimately end up, or you had reason to know would end up, with a prohibited entity, prohibited individual, or a prohibited country. Okay, let's turn to case number 3, and this is one of my favorite cases to talk about. It's called Elf Cosmetics, and this is all about supply chain liability. And the facts are really important in this case because Elf, a California cosmetics company, had to pay nearly $1 million for violation of the North Korea sanctions program. And this was a settlement with OFAC in 2019. The specific facts are really important, and they show what aggressive enforcement of supply chain liability can occur. On January 31st, 2019, OFAC announced the settlement, and Elf violated the North Korea sanctions by importing 156 shipments of false eyelash kits from 2 suppliers in China. And those suppliers had incorporated materials sourced from North Korea. The total value of the illegal shipments was approximately $4.4 million. Elf's OFAC compliance program was non-existent or inadequate. Now, Elf imported these from the 2 suppliers in China that contained these materials from North Korea, but Elf did not know, nor did it ever discover, that 80% of the false eyelash kits contained materials from North Korea. Even though it didn't have this knowledge, Elf was held responsible. And Elf's violations and failure to act occurred as part of its supply chain risk management. Elf failed to discover the sourcing of the false eyelashes from North Korea, and Elf self-disclosed and voluntarily disclosed the apparent violations. In explaining the basis for holding Elf liable, OFAC cited the high-risk nature of the transactions given the proximity, geographic proximity of the Chinese suppliers to North Korea, and Elf's failure to conduct any supply chain audits to verify the actual source of the materials in its supply chain. As part of its remediation, Elf instituted enhanced supplier audits and compliance certifications to mitigate future violations of sanctions. As noted by OFAC, Elf failed to exercise sufficient supply chain due diligence while sourcing products from a region that poses a high risk of connection to North Korea. That's case number 3, and we go to our final case, which was, and I think this is an important and instructive case for those foreign companies that have U.S. operations. This is a case where the failure to establish U.S.-based compliance programs focused on sanctions and export controls was found to be the wrong decision, and it led to some problems that we're going to describe here. And also, it was an important reminder on the importance of merger and acquisition, post-acquisition due diligence, and audits to ensure compliance when you acquire, let's say, a foreign company acquires a U.S. company. So foreign companies with U.S. operations are struggling to navigate the landscape of sanctions compliance. And OFAC has definitely expressed its concern about these challenging opportunities for foreign companies. And in the context of a settlement that occurred with Murad, LLC, a U.S. cosmetics company, over an 8-year period ending in 2018, Murad illegally exported goods and services to Iran in 62 separate transactions worth approximately $11 million. Murad was acquired by Unilever in 2015. Once discovered, Unilever voluntarily disclosed the conduct to OFAC. The fallout from the long-running conspiracy, Unilever paid $3.3 million to OFAC for its Iran sanctions violations. Interestingly, OFAC prosecuted a former senior executive, Executive One from Murad, and settled with Executive One for $175,000. Executive One committed 3 separate violations as the manager of Murad during the period between June 2016 and September 2017. OFAC credited Murad for voluntarily disclosing the conduct, but found that the conduct was an egregious violation under its penalty assessment factors. Now, the conspiracy was hatched in December 2009 when Executive One, other Murad executives, and the CEO of an Iran distributor entered into an exclusive agreement to sell Murad's products in the Middle East, including Iran. Executive One signed the distribution agreement, and Murad began exporting its products to Iran through the distributor, while Murad had a pending application before OFAC for a specific license. In May 2015, Executive One signed a new distribution agreement with the same Iran distributor's CEO for a related UAE-based company to become Murad's sole distributor in the Middle East. Iran was not specifically mentioned, but Murad and Executive One should have understood that the UAE distributor would continue to export products to Iran. In July 2015, Unilever agreed to acquire Murad. The transaction closed on September 1 of 2015. During this period, Murad submitted another application to OFAC for a specific license to export its products to Iran. Murad continued to do this, even though it never received a specific license to do so. Murad also provided support to the UAE distributor to open and operate a Murad-branded store in Tehran, Iran. Murad never disclosed to Unilever its prior and ongoing business activities involving Iran. Unilever did not discover the conduct during its pre-acquisition due diligence. Unilever never discovered that Murad maintained a website for its Iran business activities under the web address murad.ir. The Murad website in Iran was active from September 2012 until December 5, 2018, more than 3 years after Unilever acquired Murad. Unilever discovered Murad's business activities in Iran on October 20th, 2015, 6 weeks after the acquisition closed, when a Unilever U.S. employee received an email sent from a UAE distributor CEO to a senior Murad executive explaining the time it took for Murad's products to reach Tehran. The next day, Unilever's general counsel directed Executive One to instruct the UAE distributor to cease all exports to Iran. Executive One issued that instruction. Prior to doing that, however, Executive One alerted another Murad executive of the need to ensure that the UAE distributor would not ever state that any Murad senior executive approved the export of Murad's products to Iran. Subsequently, in January 2016, Executive One inquired of Unilever's general counsel whether there were any changes to the sanctions program following the Joint Comprehensive Plan of Action, and Unilever's counsel advised Executive One that no relevant prohibitions had changed. And Executive One then continued to work with the UAE distributor to export Murad's products to Iran. And Murad's last export to Iran occurred on January 24, 2018, after receiving an inquiry from Murad's bank about specific payments involving Iran. Unilever again instructed Murad to advise the UAE distributor that could not sell its products to Iran. And Murad then placed an internal hold on all shipments to the UAE distributor. So what's interesting here is how OFAC characterized the deficiencies in the program, Murad and Unilever's program. First, they cited several deficiencies, including the absence of a specific sanctions compliance program, the high-level executive participation in illegal conduct, and the absence of any compliance structure in relation to the specific sanctions risks Murad faced. OFAC cited specifically Murad's reporting line on sanctions compliance issues to personnel in Unilever's division in the United Kingdom. Notably, OFAC cited the fact that the United Kingdom staff, quote, lacked an adequate understanding of OFAC sanctions, close quote. So to reinforce an organization's commitment to sanctions compliance, OFAC specifically cited that, quote, in some circumstances, placement of a U.S. entity under the compliance structure of a non-U.S. entity that may lack familiarity with U.S. sanctions laws could prevent prompt identification of and response to potentially prohibited conduct, close quote. Finally, OFAC noted that the Murad case underscored the importance of pre- and post-acquisition due diligence and integration to identify and promptly remediate compliance deficiencies. In particular, OFAC stated that once an acquisition closes, companies should closely oversee their new business to identify potential sanctions issues. Compliance reminders by themselves may be inadequate to prevent a sanctions violation. That's another fascinating case. All 4 fascinating cases, and I'd commend you to take a look at them. We'll include the links to the show notes, to the 4 cases in the show notes. Take a look at them yourselves. They're great reading and important principles for all of us to think about in trade compliance and in sanctions compliance. Well, thanks again, everybody. We'll see you again for another episode next week on corruption, crime, and compliance.
If you enjoyed this episode, the best way to support the show is by subscribing on your favorite listening platform. To learn more and connect with Michael Volkov, go to volkovlaw.com.